Good morning, Your Honor. Luke Busby for the record, Nevada Bar 10319, appearing for our Nevada judges.
Good morning. This is case number D-12- in the matter of the petition by let's go ahead and start with the attorneys. Mr. Jones, are you yeah, you are. You're present via Zoom. Would you go ahead and state your appearance and introduce me to Mr. please?
John Jones, bar number 6699, appearing on behalf of the plaintiff, who I thought was going to log in, but maybe because this is not really substantive, she may not.
Surprise, surprise. She's actually in court this morning. So good morning,
okay.
ma'am.
I didn't see her log in.
Go ahead and be seated, please. Miss, go ahead and state your appearance, please. Good morning. Thank you for appearing. You can go ahead and sit down. Do I have a...
He's not here today.
Hold on. Let the record reflect that is not here again. Okay, and then do I have... is it Mr. Busby?
Yes, Your Honor. I'm on Zoom.
Good morning. Go ahead and state your appearance and introduce yourself to me.
Good morning, Your Honor. Luke Busby for the record, Nevada Bar 10319, appearing for our Nevada judges.
Okay, and then do I have the guardian ad litem?
Morning, Laura Deeter, 10562, guardian ad litem.
Good morning. Thank you guys for appearing. We're here today on an objection to the media request, which was filed by Mr. Falcone, and I think that would be Nevada. Does he go by Falcone, or does he do it by our Nevada judges, Mr. Busby?
I think he uses both, Your Honor.
Okay.
He files the media requests often under his personal name, but it's for his nonprofit, which is our Nevada judges.
Okay, thank you very much. I issued an order stating that if anyone had an objection, they needed to file it. Ms. has filed an objection. There has been a reply to the objection. I've read all the paperwork. Well, first off, before I get to that, at 1:38 this morning, Ms. filed an ex parte motion for a continuance. In essence, what she is asking the court to do is to continue this hearing until, and I'm quoting, this ex parte motion seeks to continue a hearing on the court's calendar after the Supreme Court of Nevada renders a decision on the petition for rehearing in Mr. Falcone's writ that was returned on March 1st of 2024. Once again, she did that on an ex parte basis. I don't see the need to continue this hearing, so I'm going to go ahead and deny that ex parte request. With that being said, like I told you, the court has read the documentation that you filed and the specific objections that you set forth. If there's anything else that you feel you need to add to that, go ahead and do so right now.
Yes, I have the first question for the court is, Mr. Falcone is not a litigant in this case, and Nevada sealing rules require, if he is attempting to unseal this entire record, I am asking the court, when did Mr. Falcone file the required motion to unseal this case? Filing a media request is not a motion, and further a sua sponte ruling based upon a media request when we already have a court order since 2020 that this case was sealed by statute. If he is seeking to set aside the ruling September 17, 2020, that was already imposed in this case, and he's attempting to bypass Nevada rules governing sealing and redacting court records, I need to know when he filed his motion.
Okay, what else would you like to tell the court?
The most important thing is, yeah, this entire media request and intrusion into this case is based upon a writ that was granted and now has been returned to the Supreme Court because they just granted a petition for rehearing. That petition for rehearing was filed yesterday. Therefore, his ruling, his advanced opinion, no longer exists at the moment, Your Honor, until we have a ruling on that petition for rehearing. I think this is pretty much a moot point at this juncture. I also just want to place on record that who was joined to this action last year has also placed on record an affidavit that she does not agree for her case to be disseminated across social media platforms. And I'm trying to figure out how we even got here. And then with the writ being returned to the Supreme Court, his ruling doesn't give him any grounds to set aside Nevada statutes that already sealed this case, and like I said, I'm kind of flabbergasted. My objections, if you've read everything that I put on record,
Ma'am,
statute.
I've told you, I've read everything you
Okay.
put on record, so we
Okay.
don't,
We don't have to rehash
we
it?
don't need to spend an hour going through that.
Okay.
So it's your position that the petition for, first off, I haven't seen a petition that was filed, but if there was a
It's
petition.
attached to the ex
Stop,
parte
stop,
motion, Your Honor.
and allow me to finish, please. If there was a petition for rehearing filed yesterday, it is your position that that petition for rehearing would, and this is my word, not yours, stay or in some way make the Supreme Court's prior decision invalid at this time? Is that the position that you're
The
taking?
writ was returned to the Supreme Court, and the petition rehearing is attached to the ex parte motion.
Okay.
Marshall Willick is representing Mr. Minter, and yes, because his writ was returned to the Supreme Court in Nevada, it's no longer valid until this petition for rehearing is ruled upon. I mean, that's just basic court procedure. So I don't know how we're gonna even move forward on any level here. And it was returned on March 1st. If you pull up the docket, it's
Ma'am,
clearly written.
okay, that's not, that's
Okay.
not, I'm asking you to assert your position, and you've
Okay.
asserted your position. Your
Okay.
position is the petition for, the granting of the petition for rehearing, which I'm assuming is your position, invalidates the content of the order. That's interesting. I may have to do some research on that. I haven't heard that. Okay, with that being said, I appreciate your time. Thank you. You may be seated. Mr. Busby, would you go ahead and make representations? And if you could for a second, address that last issue that I just discussed, because that's sort of a new one for me. I wanna see both sides of that issue if you can.
I'd be glad to, Judge. And just, Your Honor, just for the record, also, I'd like the court to know that Mr. Falcone is attending. I just saw him in the courtroom there.
Ms. Falcone?
So-
Good morning.
Your Honor, the Falcone decision that was issued in Falcone v. Minter is the law of the land as of today. Mr. Willick, on behalf of some amicus parties, has filed a petition for rehearing. There's been no reversal of the Falcone decision by the Nevada Supreme Court. I think the confusion is arising based on the kind of antiquated language surrounding the way a writ petition is served upon the inferior body after issuance of the writ by the Supreme Court. Basically, they issue you an original and a copy. You serve the copy, you show the recipient the original, and you return the original writ to the Supreme Court with proof of service. I think that's where the confusion is here. But a decision that was issued in
So can I
Falcone.
stop you one second? You're saying the confusion is on the part of Ms. in understanding why the return was made?
Correct, Your Honor.
Okay.
Yes. And so that, the Falcone decision is the law of the land. And it bears directly on the issues before the court here today. Firstly, the Falcone decision invalidated a Nevada law which allowed a party to demand closure of a court proceeding basically via option. Mm-hmm. And what the Falcone court determined was that rule ran afoul of First Amendment protections of the press under the First Amendment to view court proceedings. And that was primarily the case because when First Amendment questions arise before a court, the court is required to apply strict scrutiny. And a strict scrutiny analysis involves a demonstration of a compelling government interest in closure of the proceeding. And any closure based thereon has to be narrowly tailored to accomplish that interest. The court in Falcone found that the statute ran afoul of that rule by basically circumventing that required First Amendment analysis and excluding the press, such as Mr. Falcone, from observing court proceedings. That same analysis applies to the statute at issue in this case, NRS 126.211. And for that reason, we object to closure based on that statute.
You see, can I stop you for a second? I've read the
Please.
opinion. I've read the opinion 5, 6, 7 times, and that's the question. You just hit on the question that I had based upon the opinion. The opinion declares unconstitutional a statute. The opinion declares unconstitutional 2 rules. The opinion does not declare unconstitutional the chapter 120, I think it's 2.11 if I'm not mistaken. However, the rule that's one of the rules that's declared unconstitutional specifically makes reference to that statute. So why don't you take a couple of seconds, couple of minutes, and just tell me what your interpretation. How do you see the opinion affecting 126.211?
Your Honor, we think the same analysis that the Supreme Court applied in the Falcone decision would, by necessity of logic, have to apply to the paternity statute at issue here. The Supreme Court did what it did in the Minter case, we believe, because it had an actual justicable controversy before it based on the rules in that statute. It didn't make a broad sweeping ruling, but if you interpret the decision basically requiring a First Amendment analysis in all cases of court closure where a First Amendment press issue is at stake, that same logic we think would have to apply to the statute that's at issue in this case. But, in the prior proceeding, there was no, case or controversy based on that particular rule. If I may, Your Honor, I have a few more points.
You see, let's talk about this for a second, because you said they made no sweeping. I kind of read it a little different. The way I read the case, and I'm sort of, in my notes, I'm sort of paraphrasing what the Supreme Court said. The Supreme Court basically, in my mind, said Stevens Media provides for a right to access in criminal proceedings. They went on to say that right to access is extended to include civil proceedings, including family law cases. And then they went on, and it might have been the sentence before, but they went on to say it is presumptive. Court actions are presumptive to be open. So in my mind, that is sort of a sweeping statement. And that's why I asked the question with regards to Chapter 125 versus 126. And I understand the position that you're taking. The Supreme Court went on to say, and this was really interesting, there is no reason to distinguish family cases from civil cases. Once again, a sweeping statement in my mind. But go ahead, finish off your argument. I'll make my decision.
Thank you, Judge. And we agree that the broad interpretation by the Nevada Supreme Court based on Stevens Media and several Supreme Court cases, Globe Media, Press Enterprise, seminal cases requiring press access in court proceedings would render the statute at issue, in this case, unconstitutional if applied without the constitutional analysis. A couple other points that we think may be germane here are that it doesn't appear to us that this case was filed as a paternity action.
Yeah, I noted that too. It was filed as a complaint for custody. I went back. The complaint for custody was filed September 19th of 2012. That's a very important point, I believe. Correct me if I'm wrong. The Falcone decision was based upon a complaint for custody, right?
I believe so, Your Honor. Yes. It was a custody dispute between unmarried persons.
Yeah.
Which was an interesting, wrinkle given the nature of the rules at stake in that case.
Yeah.
And the third point that we'd like to make is that the statute at issue here actually does what we interpret could allow for the constitutional analysis to occur in this case. It does contain an exception. It's not crystal clear, but we think in order to pass constitutional scrutiny, if the court is to apply restrictions to Mr. Falcone and his coverage of this case under the rubric of Supreme Court 230, it would be required to conduct the required constitutional analysis, which would mean identifying, the compelling interest at stake, of either the government or a person, and then narrowly tailoring any restrictions that are imposed to meet those interests. And based on, the representations that we provided to the court in our responsive pleading or briefing, we think, Mr. Falcone is already going to do that. He will not disclose any personal identifying information, and should the court allow court access or camera access, it could exclude video coverage of the parents and children. And we can't think of any other compelling interest or that could be narrowly tailored that would justify exclusion for Mr. Falcone here.
I'd seen that. All right, I really appreciate your presentation. Before I go back to Mr. Jones, you have any comment?
Well, Your Honor, I mean, practically speaking, I believe that if there was an inclination by either my client or Ms. to file a motion seeking the sealing of this case under the required criteria under Falcone, I think that this court would have sufficient basis to prevent media access based upon sort of the guidelines set forth in the Falcone decision. Once we got that, as you know, my firm represents a lot of high net worth, high income, high profile individuals. So we started panicking. Okay, we need to put together the monster motion to end all motions that would compel the court on a case-by-case basis to recognize that in a case like this, particularly, we have a hearing in April and the child emancipates in May.
Yep.
What value is media coverage of this case at this point? And I understand there's a long history in this case. It was all over the internet for some reason because people don't have lives. But practically speaking, I think there's sufficient facts for this court to issue the order if the proper motion is filed.
Okay. Appreciate it.
That's my commentary.
Ms. Deeter, your position?
Thank you, Your Honor. Some of my concerns go beyond the issues today, given Ms. prepared an affidavit for the minor child.
I got to tell you, I was concerned by that too. It always concerns me when parties don't follow court orders, and it seems to be somewhat of a theme. As a matter of fact, I think I've already issued. In any event, go ahead and finish.
Well, and those issues are not before the court, but I appreciate the court's concern, and certainly there's issues regarding the violation of the no contact order based on the affidavit alone, plus many other incidents that have been occurring. As far as media access, my concern is, yes, 17, but this is, I don't think anyone would dispute, one of the most high conflict cases. Our docket is up to 872 filings. I don't see how it would serve his best interest to be able to watch all of this on YouTube. Even though, you're redacting information, you're trying to limit exposure, in any case with this much contesting, it's just not in a child's best interest to be able to watch the parties. She deals with it enough in real life to also watch all of the court proceedings and be able to be, fully aware of what's going on. The goal is typically to screen children from the court proceedings and make sure that they are not a part of the process. And with media coverage, I think you're potentially opening the door to those issues, which is one of the criteria, the impact of coverage upon the right of any privacy or party or witness. And that's my primary concern.
Okay, I appreciate it. Ms. Hammer?
And I share those concerns, Your Honor.
Yeah. No,
I was talking more procedurally.
Yeah.
But
look,
there's no circumstances under which benefits from this.
One of the issues that will run concurrently with all media requests in family court cases is, of course, going to be the best interest of the child and how media access could adversely affect those best interests. That's something that we're going to have to deal with repeatedly down here. And I'm going to announce my decision. You're going to agree with it. You're not going to agree with it. It is what it is. Miss, this is going to be your last opportunity. Go ahead.
Just a quick question for the court, so I can.
Ma'am, this is not, with all due respect, this
Okay.
is not your opportunity to ask questions of the court. This is your
Okay.
opportunity to make an argument on behalf of your objection as to why I should not allow media access. So go ahead.
Okay, well, considering right here it state, Nevada Revised Chapter 126 is very clear. The parties have never been married. We have a paternity action here in the matter of the petition. Statute requires it to be closed. Federal law requires it to be closed. If you allow them to go through and report it, then Nevada is in jeopardy of losing their Title 4D funding under NRS 425.405. I don't know how this court is going to circumvent state law and federal law to allow media access in this narrowly tailored case, which is paternity. Again, I'm kind of don't know how Mr. Falcone even arrived at gaining a hearing without even having a motion filed. But still.
Well, I would suggest, in regards to that, I would suggest you look at the Supreme Court rules, okay? But once again, I'm not here to answer. I'm not here to answer those questions for you
The
today.
sealing and redacting record, or what do you call it? I'm so sorry. This case was already sealed, closed as required to be closed, and that's, and not like they already opined that child doesn't want it and it's not in her best interest and she will emancipate in just a few weeks here.
Okay, I appreciate your position. The court makes the following findings. This case was commenced on September 19, 2012, when filed a verified complaint for custody. It has now been in the system for a period, what is that? That's almost 12 years, a period in excess of 11 years. The court also makes the finding that the Nevada Supreme Court issued an opinion in Falcone versus Minter, and I hope I pronounced the name correct, Easler. The opinion is at 140 Nevada Advanced Opinion 8. That opinion was filed February 15th of 2024. In that opinion, the Supreme Court makes reference to, and I previously stated this, another case by the name of Stevens Media, where it was specifically set forth that the media has the right to access criminal proceedings. In the Falcone opinion, the Supreme Court extended that right to include civil proceedings, and specifically stated that civil proceedings include family law cases. The Supreme Court in that case stated that it is presumptive that court cases are to be open to the public, i.e. the media. The court went on to state that there is no reason to distinguish a family court case from a civil case. The court gave me, as a judge, directive. The presumption that it previously stated that I referred to can be overcome only if, and it set forth 3 factors. Number 1, closure serves a compelling interest. Number 2, there's a substantial probability that without closure, compelling interest would be harmed. And number 3, that there are no alternatives to closure that would adequately protect the compelling interest. The Supreme Court went on to say, District Court, before you can close proceedings, you must analyze the following. Number 1, whether the party seeking closure has advanced an overriding interest that is likely to be prejudiced. Number 2, whether closure whether the closure is necessary to protect the overriding interest. Number 3, whether the trial court must it directed that the trial court must consider reasonable alternatives to closure. And number 4, that findings must be made to support closure. I believe the directive of the Supreme Court, whether you agree with it, disagree with it, I believe the directive of the Supreme Court is quite clear, and I am charged with following that directive. With that being said, I find that while the best interest of a child is certainly a compelling interest, which the court is to take, which I am to take into consideration in this case, I believe that we can address the best interest of the child without an order that the case be closed. Therefore, I will deny the objection that was filed by Mr. I will grant Falcone media access under the following, with the following provisions, and I think there is to be no personal identification information provided. There is to be no, I'm going to say faces for lack of a better word, which would identify the parents nor the minor child. With those protections in place, I think I've satisfied the analysis that has been set forth by the Supreme Court. I will also make another note that the argument that Ms. has presented with regards to the writ being returned is a very interesting argument. I got to be honest, I think she's wrong. I think the explanation provided by Mr. Busby is probably the right explanation there. The writ has to be served. The return of the writ, in my mind, is the service. Now, by the same token, if the Supreme Court, I'm sorry, I don't remember the date that was set for the rehearing, but of course, if the Supreme Court reverses itself with regards to the content of 140 Advanced Opinion, Nevada Advanced Opinion 8, which was filed February 15, 2024, I'm sure that will be brought to my attention right away. With that being said, that will be the order of the court as we proceed to evidentiary hearing on April 24th of 2024 at 9 in the morning. I thank you all for appearing. I appreciate your time.
Your Honor,
Thank you, Your Honor.
if you have one more minute, I just
Yeah,
have one
I do.
comment clarification.
I do. Go ahead.
Related to the case. First of all, it's possible that Mr. Willig will seek a stay of the application of Falcone of family cases. Obviously, if that order issues, that would change this court's ruling.
Oh, of course.
Okay. And then the other issue is more of a housekeeping issue. There have been wholesale violations of the custody order, mom picking up the child. My intention would be to submit a brief motion for order to show cause. I think Ms. Deeter even commented on the many violations. Would the court just simply set that for the evidentiary hearing?
That's what, from an efficiency perspective, that would be the best way to handle that.
And that's what I figured. Okay, I just wanted to make sure, because that's what I've advised my client was the likeliest outcome of the filing of a show cause motion.
Yeah.
And since we're here on this other matter, I wanted to make sure I understood the court's preference in that.
Yeah, from an efficiency perspective, if that motion is filed, and I would consider the issues presented by the motion at the same time as the evidentiary hearing.
Okay, thank you, Judge.
Thank you. All right, I appreciate your time. Have a great day.
Take care.
Thank you, Your Honor.